because I have to give you an hour for lunch. And I've broken that down as 9 till 12, get 3 hours out of the way, and then 1 till 3 this afternoon. But all of a sudden, as with last night, doesn't seem a very long amount of time.
Yeah.
That's a good. Yeah. You don't necessarily need to pull out unless you have no chance. If we have the hour, we'll come back and
It doesn't make any difference to me. I don't.
You don't eat
I don't stop for lunch anymore, so I didn't. Thank you. Because this is obvious. This is just me, but because it's not a buffet, which I think ordinarily wouldn't like. A buffet isn't a dream. You'd rather it was cooked fresh, but I don't like not knowing what I'm going to get when it comes to cooked breakfast, because I'm very specific about bacon and eggs and how they come.
Yeah.
And then the Pomodoro is all laid out there, and it's all perfect and it's all nice. And in the Moors, it's behind closed doors, and I don't want to risk it, because if I don't have the bacon, I won't eat the bacon. I'm not like that for other foods. I'm not like that for anything else. It's just breakfast. I am.
And it's not just more, so it's
I'm very picky. No, anywhere we go, if you've got to order it, I'm picky about breakfast. Hot breakfast. No, exactly. Yeah, I agree. Yeah.
That's breakfast all Everybody else,
It's just breakfast. I'm not No, I had granola and some toast. They have nice toast in them. I'll recommend it. I think that costs about 15 quid for to say that Channel Island prices. It's probably not unreasonable. That was all I had for 15 quid. Anyway, that was derailed me. So yeah, we can stop at 12. We can have half an hour. We can finish earlier. Whatever makes no difference to me. Let's see how we get on. Like I said, I intended to finish at 12, but we can always run on a bit later. The alternative was, you see, that I split the session evenly, which meant we'd have been finishing at 11:30 for lunch, which I thought was far too early. So, crack on. What are the duties then that the court said in Carlisle the directors of the Guernsey company owe? Mm-hmm. So the headline duty was of loyalty, yeah. Mm-hmm. Mm-hmm. Yeah, well, no, that's it. It's a fairly neat little formulation. It's quite well done for what it's worth.
And it's skill and care.
Mm-hmm. Yeah. Yeah, here. So, yeah, best interest of the company, exercise independent judgment, avoid conflicts of interest, act for proper purposes, and exercise due care and skill, which I think is on the preceding slide. None of that's surprising, all that aligns with the English jurisprudence. But to what standard? By what standard are those duties assessed? Yeah. I think you should become a judge, Lauren. Include things like that in your judgment. One of my colleagues has just been appointed as the deputy district. We were saying recently, it's probably the way to go because it means you don't have to deal with clients. If we didn't have clients, our jobs would be great. We'd love our jobs.
The lawyers.
Yeah.
Correct submissions.
Yeah.
Missing all the deadline cases.
Problem in the UK courts at that level is you are dealing with everything, all the basic family stuff and personal injury stuff that all goes to the lower judges. Anyway, so Carlisle, the court says the standard of care is indeed assessed by reference to subjective tests. So they carry that through across these duties. They're looking to the director's knowledge, skill, and experience, and that's reasonably expected of someone with the equivalent function. So I highlight that because it's an important part of the judgment in Carlisle. What standard are these duties assessed? And so it's something that needs to be included within your discussion. Importantly here, because on the facts, I think Ollie said earlier, Archie is indeed a qualified accountant, and that will be relevant to the court's assessment of the extent to which he's complied with his duties. And certainly, as far as financial matters are concerned, he'll be held to a higher standard. Did the court say anything more about the factors to which it would have regard when assessing the standard of care? You would have thought that this subjective formulation would probably be enough.
There's things that's right. There's things about the size and nature of the company's business, the remuneration randomly of the director. Yeah, yeah.
The court went on to mention, I think, slightly oddly, these other factors that it might have regard to when assessing the conduct of a director, but you know, the wording there I've taken more or less from the judgment. The following factors can be used to evaluate, and this is going to care, skill, and diligence. The care, diligence, and skill reasonably expected of a director is all a bit, I don't know, airy-fairy. It's not, the court didn't really commit itself to saying that these are factors, rather they can be used. And nor did it go on to expand on the reasons why or how these factors could be relevant to determining whether or not the standard expected of a director has been breached. And frankly, the reference to remuneration, for example, or size of the company, those just fly in the face of the English jurisprudence, which is, it doesn't matter. Effectively, all directors are treated on the same level playing field unless they're subject to a higher standard by virtue of their experience, their knowledge, etc. But nevertheless, that's what the court said in Carlisle. So it may be that you want to consider somehow introducing those elements, but I would do so with caution, given the lack of clarity as to how the court or later courts will I don't know, apply and give weight to those factors. But nevertheless, something to be aware of. On the facts then, which of those core duties are relevant? We want to advise Joan that there's prospects of succeeding in an application under the misfeasance provision. We need to explain what the basis, what the grounds for that application would be. We said earlier that we'd be fitting it within some breach of fiduciary duty, which necessarily means explaining what those potential breaches would be.
Conflict of interest benevolent housing to some degree, maybe with Bella not actually being involved in the child.
How have the courts historically addressed the issue of independent judgment? What's that geared to?
It was more when it's non-execs, for example, they're relying on execs. I think what Carl says is you're entitled to take their views if they have more knowledge in the day-to-day, so if they take into account.
Yeah.
And it's not unreasonable to follow their suggestions, but you still have to exercise some degree of independence.
So it's
probably not really relevant here.
It is. It comes back to the point that we discussed earlier, and I mentioned the case of Lions West Leeson. It's the fact that, well, it's no defence to suggest you just didn't know what was going on. That's clear. What's less clear is the extent to which you can simply rely on the work being undertaken by others. That's what's less certain in the law, but which is potentially relevant here. If she were to say she simply relied on Archie and Charles, the fact is there's no suggestion either way here. She simply hasn't been present at the board meetings. Which doesn't necessarily go hand in hand with saying she hasn't exercised independent judgment.
I mean, she could have received agendas.
Yeah. She's simply, my intention when writing this was she'd simply absented herself from the company. And it would be no defence for her to say she didn't know what was going on. Any allegations as to breach the duty of conflict of interest, does that go to all three directors? Okay, so we'll come on to that in a moment then and go Archie-centric, but just sticking with the others generally, we haven't really firmed up, I don't think, have we, on a cause of action against certainly Bella and Charles. What else, if anything, have they failed to do, looking back to the core duties? Yeah, I think that's probably it, isn't it?
Because Bella hasn't exercised any care or skill.
Yeah.
That looks at it, and what Charles
Mm-hmm. What more could Charles have done, though? You're saying he's not exercised reasonable care and skill. What was his position in all of this?
Well, he said the company should cease trading immediately.
Mm-hmm. And he objected to the purchase of the new store.
I don't know, I don't know what if the group should have mentioned that Bella was involved and she then had a fight in mind, maybe the two of them put him on the board with majority and stop the purchase from happening.
I think that's going on a limb, frankly. Given my experience of certainly the English court's approach to this, I don't think they'd have any particular concern actually with Charles.
I guess he could have resolved
He took on steps. He said, I think he voted against. He said, next Friday, maybe we advise John that
refusal to speak so much.
Yeah,
he's likely to be relieved from liability. Or there's a risk that he may be relieved.
He should just sort of simply close his mind to the company.
yeah.
And I think maybe he should have perhaps resigned at that point. sit out. Nothing else to do with that.
Again, it's got scope, hasn't it, for a discussion that kind of doesn't lead anywhere, which, as I said, where you've got opposing arguments, you don't need to come to a certain conclusion, but equally you need to avoid these situations where you've just got a kind of trailing off discussion. Headline point for Joan is, on the facts, there probably isn't a clear cause of action against Charles for breach of duty, but within your discussion of wrongful trading, he could be criticised potentially for not taking any further steps to minimise losses to creditors. But we've discussed that and we said, who knows how Archie's plan would be treated by the court in the context of wrongful trading.
Or wouldn't the court be reluctant to postulate on that company?
It's difficult, obviously, that whole point of the fact pattern is not to give too much detail.
Yeah.
In reality, my gut would be the court would say they should have ceased trading. The English court would have said they should have ceased trading. You don't go out to expend another 100,000 on a.
That's already very risky.
On a potential venture. I think the court would be unhappy with that. And also because of the potential conflict of interest. So, I don't know, Jasmine said a few moments ago, that attaches to Archie only. What do we need to say about conflicts of interest? It's a duty to avoid them, okay? But obviously that's things that happen quite routinely, given the very...
But disclosure is...
Disclosure.
Disclosure of it. And abstain
Some
from
of the
voting.
articles say cannot vote.
Yeah, this was my main article. He then had the casting vote. But he should have probably abstained from voting. I wasn't sure where that leaves us. That to me seemed like a pretty big red flag.
This is kind of, for me, this was like kind of naughty.
Yeah.
Because it's not like you can just say this applies because it's a bit more like articulated, you know.
So the starting point is probably, is it a potential conflict? Okay. Why?
Is that the word used?
Yeah. Well, the law specifically defines spouse, partner, father, parent, etc. There's various slides. I don't think I can neatly pull one up. Okay, so it's likely to be a conflict, and is it disclosable? Therefore, it would be disclosable under the law. Yeah, and then you've got another series of slides that deal with disclosures. Okay. What then are the procedural points that go to disclosure? What follows in the event a disclosure is or isn't made? Has a disclosure been made on the facts? Where do you get to with that kind of analysis?
I mean, I might be jumping ahead, but there's the 1624 where just because he hasn't complied with it doesn't affect the validity of the transaction.
Yeah, quite right.
We flag that as like possible obstacle.
And it is jumping ahead, so only in has a disclosure, have the disclosure provisions been complied with or not?
No, well, it was, they said the price seems fair or something, what does it say? Although the price paid for the store was reasonable, I mean, that's probably not enough of a tax to conclude if it wasn't arm's length. Then the terms. If it wasn't, sorry, if it wasn't standard terms and conditions. In the ordinary course of business, well, it wasn't in the ordinary course of business. So I think it's not been complied with. That's where I'm at.
It's not, I mean, I'm not saying this because sort of, I'm just going basically on just rational logic, but it's just because he said, just because it's known that it's his daughter that's the other side of the transaction doesn't amount to declaration of interest.
Yeah.
So there's like the disclosure of interest procedural requirement. It's more procedural than substantive, right? So he's going to declare, then he can vote if he's allowed to.
So I think the price there is that we're simply not told whether he has or has not disclosed.
But yeah, but I think the fact, I think there's marks to be had for
absolutely.
proceeding on the basis that no declaration. Right. So,
Yeah. You're both right, because the intention here, again, when drafting it, is that it's not made that clear whether or not the relevant requirements have been complied with. So you're absolutely right. There's that. There would be marks for that discussion of, well, if a disclosure was not made or a compliance disclosure was not made, or so on and so forth. If it was, let's come back to what I said earlier, is you've got two opposing arguments potentially, and you can develop both of those based on the limited information you've got. Excuse me. It doesn't come then to a defined conclusion. Yeah, related party transaction, therefore potential conflict of interest, and would be disclosable. We don't know whether or not he's followed through procedure for making a declaration. Ultimately, he votes on a resolution pertaining to the transaction in which he is interested. How does that work then? How would the law on either of our two arguments?
It can be ratified.
Is there any situation in which he would be entitled to vote, notwithstanding that he's interested in the transaction?
The articles about it.
Mm-hmm.
The articles about
yeah.
and go for a shower.
The articles
Yeah.
If you warrant that. If you warrant that.
Yeah.
They must have disclosed.
Yeah.
Oh yeah, so assuming that he had, yeah, he can potentially vote on it. And if he hasn't,
Not that you shouldn't vote.
yeah,
Yeah.
he's got a problem, hasn't he? Yeah. So again, everything you're all identifying the right points, but you're still just following through two different
And then it goes on to what
outcomes.
irrespective of whether or not we follow the right internal procedure, because
Yeah.
it's the third party, unless the third party knew those actions were there.
Yeah.
And that's a risk identified for our client, which is a risk further.
Yeah, so that's so Lawrence 162 subsection 4 and 164 deals with the third party. So it's not just that they're acting in good faith, is it? Valuable consideration without knowledge of the director's failure to dispose of their interests. Now, on the facts, it appears that proper value was given. We don't know for the other 2 points from the point of view of his daughter, but your advice to Joan is probably going to be relatively confident it's unlikely that the relief would be to undo that transaction. Rather, you come back to the general remedy for misfeasance. We can establish a breach of the duty to avoid conflicts of interest, potentially. And if that's the case, the remedy is probably not going to be to undo the transaction within the self-dealing provisions. It's simply going to be the general remedy for misfeasance under 422 subsection 3. That would be the payment in contribution to the assets of the company in insolvency. The transaction will stand. Now, that probably from Joan's point of view is a better outcome because it's simpler to claim cash from the director. Can you give any view as to what the value of the remedy might be? Can you give a view as to quantum? Say again, sorry, I didn't ask. The lost value of the property. Yeah. Because ultimately it's had valuable consideration. It's purchased this asset which has a resale value. It's fallen in value, and you can pass comment on the fact that her remedy under 422 subsection 3 would be to claim probably the difference in value. That's the level of the company's loss.
So the next one, the next section,
In which part, sorry?
163.
So again, one.
Section back to further words of the transaction.
So the circumstances in which the company can avoid a transaction within it's got a limited shelf life, hasn't it?
Yeah. But at 3 months. Here, that's correct. Right. It's quite.
It comes back, doesn't it, again, to at what point do you treat the date of disclosure?
Yeah. I just thought QA was relevant.
Why would it still not be voidable, irrespective of the timing issue under 163? Yeah, because under that's an or. So company received fair value for the transaction. So assuming that's true, that's the information you've been given, assuming that's true, the company wouldn't have avoided it. But that doesn't limit, and again, hence the importance of framing it within this thesis. I think it doesn't limit the liquidator's ability to claim a remedy. The one point we didn't follow through, actually thinking about it, is just the general duty to act honestly in the best interest of the company that we say could, they could all be potentially guilty of that. Subjective and objective tests, as we've already discussed, you've got those various factors that go into it. There isn't a huge amount of discussion there, but there's that case, Cullen and Jury, which is 1812. The English approach always being that the court won't look to concern itself with matters of business. It won't look to interfere in what it sees as being internal matters of business for a corporate venture. So there is that one potential limitation, which is that the court could view that investment decision as simply being a matter for the company when assessing whether or not Bella, Charles, and Archie failed to act in the best interest of the company. again, there's probably not much mileage in it. It's just something else to throw into the mix. I think probably it would be such a big issue within this set of facts that the court would be unhappy about it. But there is
Case that came to my mind, which we kind of discussed with us 2 weeks ago, was the one about whether shareholders or directors approved it or rejected the deal in favor of the outcome for their employees.
really well fab engineering.
That's a Cape.
No, the one you're talking about is really well fab, where the company's insolvent and they sell the business out.
Yeah.
And the question is, do they sell it to the highest bidder who's going to strip it for parts, or do they sell it to the lowest bid, to the lower bidder who's going to keep it as a going concern? Now that was in the context of the court granting relief under what is the equivalent here in terms of 522, and yeah, acting honestly, acting better. That's what that went to. Should the court grant relief? And they did on those facts. But yes, I appreciate that kind of overlap when you're looking at the interests and what drives decision making. But that was the context of that. They were talking about an application for relief from liability, which was granted. And neatly, that probably is where you end up concluding your discussion. As I said earlier, here you're phrasing it from the to the liquidator as the risk that the directors, if challenged, if allegations of breach of duty are brought against them, the risk that they may apply to court for relief from liability under section 522 on the basis that they acted honestly, etc. Does that, though, go to wrongful trading? Does that afford them a further opportunity to avoid liability for wrongful trading?
Sorry, can you repeat the question?
So in the 522, you can apply to the court for relief from liability. Does that cover off wrongful trading, or is it more limited in its scope?
So yes.
Yeah, it's limited to allegations of breach of duty, breach of trust, negligence, default. So an application for relief by any of these directors under 522 would only go to absolve them from liability for their breaches of duty. It wouldn't serve to absolve them of liability for wrongful trading. Oh, right, sorry. I thought you said yes, it is limited. That's right. I'll interpret it the wrong way.
Yes.
So, acted honestly, acted reasonably, would fairly be excused. Is Archie going to avail himself of a successful application under 522, do you think? Honestly, reasonably, ought fairly be excused.
You spell it on it, so you should close it down.
Yeah, exactly. Don't do this.
Yeah.
Probably not. What about the other two, Bella and Charles? What about Bella?
She won't be able to.
No, you're right. What about Charles? Possibly, yeah. Possibly Charles, out of the three of them, might be successful in an application under 522. He did what he could. Doing so, he acted honestly, acted reasonably, and ought fairly be excused. So with all of that, your advice to Joan becomes something like, there's on the face of it grounds to pursue an application to the court for wrongful trading, save as to the uncertainty, subject to the uncertainty as to how the court would treat this new investment, this new venture? Would they see that as being a step taken to minimize losses to creditors, in which case directors may avoid liability, or would they not, in which case there's likely to be liability for wrongful trading? As far as misfeasance is concerned, it would be framed under subsection 1, subsection C of 42, in circumstances where there are apparent breaches of duties by the directors. Bella and Charles for failure to act in the best interest of the company, to exercise reasonable care and skill. There will be no defence to Bella that she didn't know what was going on. As to Charles, he may avoid liability if he can demonstrate, satisfy the court, he acted honestly, reasonably, and not fairly be excused. Archie, on the other hand, again, failure to exercise reasonable care and skill, failure to act in the best interest of the company, and a breach of the duty to avoid conflicts of interest, albeit, as we saw, there was some uncertainty as to the application of the disclosure principles. In any event, Joan can't seek to avoid the transaction with Paula, but can likely claim a remedy from Archie under 42 subsection 3. The issue then, as you said, is you read through a set of facts like this, and you've got to identify what are the issues on which you need to advise. But again, it's trying to train yourself to identify these signposts. You read through the set of facts, you know you're advising a liquidator. So the liquidator is limited in the causes of action which they can bring. If you're advising a liquidator, you're thinking of fraudulent trading, you're thinking of wrongful trading, or you're thinking of misfeasance. The first two, very narrow in their application, in their scope. Worst case scenario, you know you can go to those in the law and simply follow through the relevant provisions because they're set out neatly. As to misfeasance, again, the broad framework in 422 is straightforward. But the detail of this discussion is going to come from the law relating to directors' duties. But for the liquidator, your discussion is going to be within one or more of those three causes of action, because those are what are available to the liquidator in this type of scenario. Obviously, they have other powers exercised, but in this the context of this. If you're advising a shareholder, well, what are the causes of action available to a shareholder? What if Joan was a shareholder and the company had not yet entered liquidation? There are only limited causes of action available to a shareholder. What would those causes of action be?
No?
Shareholders will have got a question whether they can bring the claim themselves because it's actually an action of the company. It's loss caused to the company. It's the whole.
So what is it? What's that? It's a derivative claim. A derivative claim, yeah. So if Joan was a shareholder, again, just looking at signposting here, all she could do for the wrongs caused to the company would be to potentially pursue a derivative claim. Or, what would the alternative be for her as a shareholder?
To
exercise control through our.
Okay, yeah, potentially.
Depending on the share.
Say I told you that she only had 20% shareholder. Yeah. So again, I'm just talking purely in terms of signposting. The causes of action available to a shareholder, if that's who you're advising, they're limited. It's going to be potentially a derivative claim. So on behalf of the company, seeking a remedy for the company. That's not attractive because it doesn't change the status quo. You seek a remedy and money goes in at board level and the board just extract it in the way that they've probably on the facts been doing. So the preferable remedy, unfair prejudice, that gives her something directly. Or, what would the final possibility be? A journey winding up. So don't forget that's there in the armory available to the shareholder. And in fact, we saw Guernsey jurisprudence, and we'll look at some market protection issues later, but we saw Guernsey jurisprudence where the court said they weren't willing to grant relief for unfair prejudice. It wasn't properly made out, but they would grant a journey winding up, which is, again, not the English approach at all. They would have tried to shoehorn it back into unfair prejudice to avoid winding the company up. Oh, yeah. So just in terms of signposting, you're advising a liquidator, well, immediately you're thinking they've only got limited causes of action available to them. Fraudulent trading, wrongful trading, and misfeasance. There are other powers, of course, in insolvency to undo preferences and so on and so forth. But just focusing here on issues where we're complaining about breach of duty. For the shareholder, you're advising a shareholder, well, again, limited causes of action, derivative claim, unfair prejudice, JNE winding up. Across the three, you can found an action based on allegations of breach of duty. It's just how you're framing it within a wider cause of action. The substance of it doesn't change. It's still looking to the same allegations as the breach of duty to justify the cause of action. If you're advising another director, the position's even more limited. And for that reason, I wouldn't ask you to advise a director on this type of fact matter, because there may be very little that if they are simply a director, they can actually do. So there's that. Who you're advising, think, well, what are the causes of action available to them? And then you kind of flick through these facts, 3 paragraphs. First one tells us somebody's a qualified accountant. It tells us about their qualifications. Immediately, you need to be thinking, right, is that going to change the standard to which they're held for the application of any test in law, whether it goes to the specific test of indirect duties or not? Are they going to be held to a higher standard? That's why you'll be given that information. Yeah, I don't want to be condescending, but just in terms of cutting through the information you're given, you're told something about somebody's qualifications. That's why. It's because it likely goes to them being held to a higher standard on a subjective test. And that is pretty much what you take from that first paragraph. 3 directors, one of them's qualified and is an accountant, and another one hasn't worked or attended board meetings. Second paragraph tells us a bit more. Well, an immediate signpost again, substantial loss. Company's been trading whilst it's been loss-making. Immediately, that goes to issues of wrongful trading. Or the potential. On the facts of this, I'd say no, because the company has entered insolvency. You can probably, you could do if you're working.
The directors consider that.
Yeah. if you're working through it, I can't remember what subsection is, you'd come to the solvency testing that's built into the wrongful trading provision. So if you were just going through them one by one, you'd come onto it anyway, because it's got its own built-in to test the balance sheet insolvency within the provision itself.
Actually, when they think that purchase, would they have to undergo the solvency test?
That's a major property transaction.
Yeah. Yeah.
But again, you're moving away into areas of unknown. And then it's all about somebody justifying why they're doing something. We don't really care what the facts are. They're justifying their decision-making process because here they want to protect the jobs of their employees. So again, this is starting to come back to, well, how do we assess the the duties that somebody owes, how they fulfill them? That goes to the issues we discussed as to applications for relief from liability. And another signpost later on in that paragraph, currently owned by his daughter, you've got a related party transaction. So again, that should be leading you to think of, right, conflict of interest, and that's the discussion there. You know, I can't unfortunately just give you a list of all of these signposts to highlight that you sit down and read the facts of the problem question, know precisely what you're going to need to discuss, but trying to train yourself to cut through the kind of chaff here, the bulking out, is just looking for these, what are actually very narrow points within the wider fact pattern, but which build up quite a significant discussion. Now, what I will say is, and I suppose if you're on study leave, maybe you will have time. Typically, people don't. If you went away and you drafted your answer to this, whether you're using your notes or not, or trying to do it literally based on the copies of the law that you exam, from memory, however you do it, if you have a go and you formulate something and you want to email it to me, then by all means I'll have a look through and tell you what I think and what my kind of gut would be as to where you would come out mark-wise, for what it's worth. But what I won't have the opportunity to do is to give you full, detailed, critical feedback. But I can certainly look through and tell you any obvious glaring errors, not necessarily based on the law per se, but more just as how you've approached it, how you've structured it, the level of content that's gone in, and how you can better balance it to perhaps be more efficient or to expand beyond what you've done to maximize the marks that you're obtaining. So I'm happy to do that.
Not a lot of questions to work on, but maybe in the next couple of weeks you might discuss like one question, just. I mean, I do.
One that not aside, outside the scope of these.
Well, not outside the scope of these, but I just want, or just tell us one from here that would be the right one. I mean, we'll just,
Yeah.
there might be one that we. I don't think we're going to go through every one of these, but maybe there's one. That's what I'm saying. Maybe there's one in here that we're not going to do that.
For example, so that you don't have to actually write a
Yeah, no, don't write a
or
question.
any of the previous papers.
Yeah.
You said the 2015 question 3, or you just pick one that's not.
But yeah, that's right. Like one like this from a previous Jersey paper, it can be 25 marks, and it can be however we like the example.
Okay, well, easy, because I didn't think we'd get as far as this. On the final page of that bundle, you've got the September 2017 paper, and the last page of the bundle will take you to question 3, which deals with Avril and Bernice. I didn't think today would get as far as that one, so I'm more than happy if you want to kind of highlight that and have a crack at that one, obviously from Guernsey point of view. That will take you through, I think, similar issues to what we've discussed today, that you're not advising a liquidator. But yeah, maybe do that. If the four of you want to have a crack at that one and draw out what you can. Otherwise, if you want to base it on one of the questions that we have discussed or will go on to discuss today, then pretty easy. But don't just access the Jersey papers, pull out a random one and do that, because
It's too market, what do you think?
because
But I get 0, 1.
the extra work would come if it was just a total random question. Whereas if you're all doing the same one, or if you're doing one of the other ones off this paper, I haven't got to join your extra work, so I know what the marking scheme looks like.
I think what you said about it might be completely exhaustive feedback, but I would just
When is the paper? When is the exam?
Sometime that week.
Oh. Well, still got 2 months. More or less. Yeah. Okay. Well, have a look then at question 3, Bookworms Limited. Let's see if this is a bit simple, a bit more straightforward for you. For 25 months. What are your initial thoughts? As a contrast to the question one.
That's harder.
Kind of harder, okay.
I thought this was easier to kind of frame.
Uh-huh.
Yeah, I don't know whether that's just because there's kind of separate questions. I mean, I would have taken this in separate steps.
Mm-hmm.
So I found that kind of easier to, you know.
What about in terms of identifying the issues? I'll come back to what Jasmine said in a moment. What about in terms of identifying the issues?
Again, it's a less, quite straightforward, very straightforward, I think.
Is the difficulty in coming to a conclusion?
There's, for my, I think it's a much more linear story.
Mhm.
The last question, which was lots of different parts of the company, is all engaged through different protagonists. But this is just one story arc.
Mhm.
So it's actually easier to follow through the kind of chain of reasoning.
Mhm.
But for me, it seems like it would be, I guess I'm picking up on what Jasmine said, it's hard to see 25 marks for this.
I'm clearly missing something
I think-
because there's old night.
I think it's I think we'd be invited to talk about cases perhaps in this one.
Okay.
But I couldn't.
Just as between the two of them, it's a useful contrast because it shows how between the different topics that you can extract from the company's law, a question that deals more fully with directors' duties or more fully with issues going to minority protection, something like prejudice and genuine up, is necessarily going to be a much longer answer, advice, you're going to work more for your 25 marks than you will with something like this, which is focusing on filtration of the articles. Obviously, you are asked to bring in duties going to discussion going to breach of duty, although as we'll come to see in a more limited way perhaps than in question 1. And we'll look at question 6 later on, but the same point applies to that. That one is, again, it's a similar length in terms of the facts that you're provided with, but the nature of your answer, your discussion is going to be shorter, it's going to be less than in that question 1. And that's fine, it's not a problem, as long as you're working through the advice in the same way, you're presenting the law completely, you're applying it accurately, you're identifying what the issues are and advancing the relevant arguments. There will be 25 marks in there. It isn't the case necessarily that you're ticking off a mark here for stating this and a mark here for stating that. There's a general mark scheme that goes to building up the 25 marks. But you won't necessarily be able to identify 15 specific points that you need to discuss to get 15 marks for your discussion of the law. Which, although you say it makes it harder in one way, in fact, the entire point of doing that is to more evenly balance the paper for you, for the students. Slightly different on the JLC because you've got 6 questions, you've got to choose 4, so you've got to choose 4 wisely. But certainly on your paper, what I've been keen to do is to balance the questions in this way so that you've got 2 more detailed, heavyweight type questions, similar to question 1 here, and something a little briefer, frankly, as you've got here with this question 3. You're still going through the same process of demonstrating your knowledge and understanding and applying it, giving an advice for the same amount of marks. It's just there's less to work through here and it's presented in a more simple way. But that's intentional, because with a full question on directors' duties or a full question on minority protection is going to be long and it's going to take time. And that's where you start to think, okay, do I trade off 5 minutes on this question to give 5 minutes extra there? Which I come back to something I said previously, which is go in assuming you're going to spend 45 minutes and you get 45 minutes on question 1, leave a page, leave half a page, leave a page and a half, whatever. Move on to question 2. You do question 2, say it's this one, it takes you a page and a bit, it takes you 35 minutes. Great. Go back to question 1, use those 10 minutes to continue. No problem with leaving your answer and moving on. No problem with leaving blank space, even if you don't fill it. It's not a problem, but it gives you the flexibility to come back as an exam technique. Okay, so yeah, the final paragraph fairly helpfully breaks this down into 3 issues, doesn't it? 3 discussion points. Is Bookworms bound by the contract build? Can Sarah do anything to prevent Bookworms converting other stores into cafes? And have the directors of Bookworms breach their duties to the company? What do you say on the first point? Is Bookworms bound by the contract with Quick Build?
In terms of framing an answer, this is what I would have done, subject to having everything to hand.
Okay.
I would have first gone in with the general position is that the business and affairs is managed by directors, subject to the articles, and they've got general powers to do everything. Here we've got an objects clause that raises 2 issues. 1, James is a director. 2, they're acting outside the objects. Taking the first point, I went to Outcroft and the requirement, I guess you're deemed to be free of limitation if you're acting in good faith. And then section 1152, which says that person is not bound to inquire and they're presumed to have good faith unless the country is proved. That's a very high hurdle because you're not going to be found to be in bad faith even if it's proof that you've got knowledge they're acting, not just the director.
Mhm.
Um,
So what's Turquoise? What is the rule in Turquoise? Where's it reflected now in the Guernsey law?
well,
Yeah. So absolutely, Turquoise kind of sets out the historic basis for that. It now exists on the legislative footing in 115 section 1 and 2. Yeah, okay.
And then I'm stuck in 1374, so this is kind of live as a director, but I think that probably be more if we're advising what actions they could take and kind of what remedies are available, so that's probably going a bit too far.
Mhm.
But generally, I concluded that on that front they could still be binding. And then in relation to the objects, I looked at 114.
Mhm.
So the validity wouldn't be called into question.
Yeah.
For reason anything kind of being or admitted from the articles, which I presume would go to, it's being managed by the directors.
So we go to the objects clause. It would go to the fact that this company is designed to do a certain thing, and they're purporting to act beyond that. Yeah, cool.
And then just rounding it off. Yes, the contract will be binding unless they can show that there's some bad faith.
Okay, so the application of 114 is straightforward. You've got an objects clause, it says a certain thing. However, even if the company exceeds that thing, that purpose, transaction with a third party will still be binding. So that underpins, I think, the position here with Quick Build. Is there any difficulty or not difficulty, is there any uncertainty as far as the application of 115 is concerned?
It's usually pretty exonerating.
Mm-hmm. And hence the kind of 114 is your rock bed to this, but just focusing on 115, what is the potential uncertainty?
Well,
Slide it.
so obviously, I think Alice. So I think the sort of last word was Alice is not through the doors, and I think about it sort of because she knows that that is the house directors, and that's quite exonerating.
Mm-hmm.
But you might just finish that thought with she's the head dealer of PLC.
Right.
And
It shouldn't be a PLC, of course, but yes. Yeah.
Sorry?
Shouldn't be a PLC for Guernsey purposes, but
Right.
yeah.
She's the MD of
A big company, yeah.
And then your management. You might say that she's kind of that exoneration is being strained a bit by the fact that it's a spotty term. And that she's called and verified that with his entry. I think you might, I think the next step would just be to say, I think actually quite dimly on that. So it would be worth pushing.
Okay.
I wouldn't necessarily stop there.
What transactions is 115 designed to protect? The actions of whom? Who's exceeding or failed to do so?
Directors.
Mm.
Yeah, so and there's that as well. Yeah, so I mean, he's not a director. So,
Mm. Is he cleanly caught by 115?
No, he's not.
Yeah. Do I have an answer to that?
No.
No, I don't. So 115, in its wording, the power of the directors to bind the company or authorize others to do so is deemed to be free of limitation. Okay, well, first point, it's not an exercise of power by a director. It doesn't appear to be the exercise of power by someone authorized to do so. But the secretary supports the position that they has full authority. It's not intended that there should be a clear-cut answer to that. It's just that the student recognizes what the strict application of 115 is on its wording. and whether or not it would be caught here. Whether or
That's
not
something that I would have
Mm.
I just got too excited and carried on like I did. But I wouldn't have
But
necessarily drawn that out.
the importance of it, everything else that you set out.
I think you nailed that question.
Yeah,
So
absolutely.
instead of getting 25, you got 23.
Yeah, it's just those little things that really came up.
But then again, thought goes into this.
Yeah.
I do sit and drink Peroni while I write them, but I don't drink so much Peroni that it's completely, you wouldn't, you would drop a mark or two.
But is the word of the secretary? Is that
Again, that point is going to what Lauren said about whether or not the MD of this other company would fall foul of
yeah.
the caveat where I don't know where it is on this. 2-3.
I mean, it'd be more believable asking.
Oh, here it is.
Someone else who's got the records of the company
Yeah.
saying these are your directors or these are your minutes. Or
But I think-
But it is simply looking, the relevance of that simply goes to here. I've got an additional B there.
I think also, I mean, there's
Was it 1, 2, 3? Maybe it's 1.
parties have been negotiating already.
Mm.
So presumably she's been negotiating.
Yeah.
But just back on the director point.
Mm.
This 115 only engages with directors.
Or people authorised. Yeah. So that is the one uncertainty you've got here. But in any event, and there's no answer to it because there's no jurisprudence, there's nothing, there's no answer to that. It's simply recognising the issue. In any event, I think the transaction ends up being saved probably on 114 anyway, because you still come back to the fact that you're acting in breach of, on the face of it, it's going beyond the objects clause and it would be saved under that. And again, I don't know because there's simply no guidance in the English jurisprudence or obviously the local jurisprudence. Okay, so that's the first part. Can she prevent bookworms converting any other stores into cafes?
This is a very great question. Because the contract is only for the conversion of the So, to my mind, just strongly worded letter.
In my mind, it's really jumping into the injunction. I'm clearly on.
I didn't actually know.
Can she prevent bookworms convert? Can she prevent bookworms? I'm not talking about sending
Yes,
I say a rude word, sending a letter, the bust letter.
I guess then just saying these are the directors, these are who buy the company, now you know. That not.
But I mean, even if they never actually do it anyway.
But I think
You can send a letter, what they're going to do. Can she do anything to prevent them? Jasmine wants an injunction. She wants,
Sounds good.
what's it going to be over here? She wants 50 grand's worth of fees, doesn't she?
I mean, you
What would
mentioned-
be the basis for that if you were going to apply
I'm
for
not
it?
there.
No, don't know. I'm not asking you to.
If you, I thought you mentioned something about operation. Is that where you were going?
I don't know where I was going. What can she do?
Is that
If
what
any-
it
They're
is?
actually outside the object, so surely she can do something. Act within the object. But I didn't know
Well,
that
I'm
again, sorry.
prejudice, but why? I can't.
It's the preventing the counterpart. That's why I said it.
This is where this does slightly fall foul of the difference between the jurisdictions. Because insofar as I can tell, there's no express reservation of power to shareholders in Guernsey that enables them to, and there may well be in bespoke articles, but not in the model articles, that enables them to direct the directors. Whereas in England and Jersey, the standard articles
Really?
contain provision for shareholders to direct directors to do something or not to do something.
And if the director
No.
But, I mean,
Yeah.
That was
then
in the
we're
old
active
school.
students with that.
That's why you promote people percentage.
That's why I wrote a percentage there. So in both of those jurisdictions, there is a specific reservation of power to the shareholders.
What's the school?
To whatever the wording is, to make hold a meeting to consider resolution proposed by the shareholders. If they fail to do so within 21 days, whatever they need for certain.
It's simpler than that. It's the Model Arts. Article 4 says the directors, the shareholders can direct the directors by way of a special resolution. 2 limitations. 1 is a special resolution. 2, it can only be used with foresight. It has to happen before the event. They have to have the foresight of the need to pass a resolution to compel the directors to do something or not to do something, which is, but obviously it's entirely intra-company. Yeah, from that point of view, because actually when I was skimming through these on the plane, it didn't even occur to me that reservation of power didn't exist in the Guernsey Arts, and I went back to them then and I read them through and I realised it doesn't. It's not there, and it doesn't exist in the law. Yeah. So there's that. The point though that I think Jasmine mentioned. What if she sought to alter the articles? So that's the more heavyweight way of doing it. You alter the articles to introduce some kind of directional limitation or restrict something.
But I think they're already acting contrary to the object.
Yeah.
So,
I'm sorry, I missed that line. But
The other side. Yeah. So
Again, she's not
the point being, in all of these scenarios, she doesn't have the weight. She is unable to do anything practical. Let's put it like that. So what does that all feed into then? Is what is the wider relief that she can see, and hence why you're taken into whether or not the directors have reached their duties to the company, which we can look at quickly for 5 minutes. I think I'll top this one off. What were your thoughts then as far as that third element is concerned?
What the general duties are, where we've got likely breaches here.
Why did you say personal right? I think you just said personal rights, did you?
Personal right, that
Oh, personal and rights. Oh, sorry. Did what Ollie did yesterday. I'm totally misheard. Sorry. What you got to realise is the worst is you, because all I can hear is the fan. You get sucked into the fan and then blown back out. Sorry, personal and right. Sorry, I thought you said a personal right, which is a very different right. Personal and right. Yeah. Okay. So you're working through that kind of broad overview. Yeah. Okay. Exactly. And so hence that discussion is far more limited because you're not getting into dominant conflict of interest, which is why you have a much longer discussion than any question on director's duties. Yeah, okay. So we're looking at acting for a proper purpose. How do we flesh it out then? What is acting for a proper purpose? How do the courts approach that? What does it extend to? What's it cover? Acting in accordance with the company's constitution. So, have I got it on here somewhere? in England and Wales, it was Rees, Smith and Fawcett, the court set out the common law formulation of the extent of that duty. Yeah, duty to act for the proper purposes of the company. And you see that it effectively has two limbs: to exercise powers in accordance with the terms upon which they were granted. The wording has been developed over time, such as that is, to comply with the company's constitution, because on the original formulation in Smith and Fawcett, it wasn't entirely clear that would cover issues going to, for example, the objects clause. So to comply with the company's constitution and to do so for a proper purpose. I'm sure you remember Pearcey and Howard Smith were both going to issues of abusing share capital and the issue of new shares to create new majorities, to protect majorities, and that's what the case law in England and Wales goes to on this duty. But it would fit in here. Rachel's absolutely right. So directors are subject to a duty to comply with the company's constitution. The constitution here limits its objects. The point that the students would need to recognise is probably it doesn't matter what the position of the third party is concerned. It becomes an internal disciplinary type issue, if you like. Once you move beyond the saving provisions in 114 and 115, just because the transaction stands, the directors don't necessarily avoid liability. A claim can still be brought against them in the usual way for breach of duty. If then, on that fairly limited discussion, you've identified that they're potentially acting in breach of duty by pursuing this course of investment and this course of changing the nature of the business, what can Sarah do? You're not actually asked to do this, but what would her next step be? You said probably bound by the contract with Quick Build. She can't directly do anything to stop further conversions, but she's identified they may have acted in breach of duty. What does she do next? She wants a practical outcome to all of this. You start to get into that whole discussion, potentially, of derivative claims, Jamie windings up, unfair prejudice, all of those kind of things start to become next steps. Possibly it would be going on a limb here to start chucking in unfair prejudice and Jamie windings up. What did, sorry, just before you do, what did Jasmine say? Because that was.
Oh, I just can't really see it.
No, absolutely. I'm not. You don't. These questions aren't phrased or formed such that you're supposed to be saying, yeah, absolutely. You've got a brilliant course of action. No, you wouldn't. But would you advise on if you've got a potential breach of duty, you could pursue a derivative?
I'm making the same point.
All right.
I'm only going to say, I can see that it was at least no, not whatever. You can talk about it now. But for me, in terms of reading through this, the unfair prejudice question doesn't seem appropriate just because there's no other shareholders in fact.
Yeah, hence I said that that's the kind of issues you're starting to get into in terms of what practical remedy could you achieve. Whether or not it's appropriate, I don't know. You don't have the information on the facts. And even then, I was only saying that as something of an aside, because here your direction is to advise on those three specific points. Probably, I can't remember, but probably I would have included a very small buffer for students who did go on to discuss probably the derivative claim and the potential that she could pursue a derivative claim. But I can't remember if I did or not. Or I would use it to give students the benefit of the doubt if I felt I just wanted to lift them above 50% so they could pass.
I guess the thing is, I just picked up on research. That we do have is a kind of clear, concrete breach of it. So you would never have that. So actually, it's totally right for actual discussion. Almost a slam dunk, actually, especially if you're trying to shareholder this. So I guess,
Yeah, you maybe need to step out of your glass-walled conference room and what you would advise on the ground, and just think, within the confines of this hypothetical scenario.
I couldn't see
do
it.
see it.
No, it's too expensive.
No, they all may be successful, and she might be happy in 6 months' time. But again, you just don't know. The point is simply, it was an aside. What would you then start to think about? And as I said earlier, for the shareholder, that is the extent of the causes of action which she can begin to think about. And I wasn't saying that is what she should be doing. Simply, that is the extent of her armoury.
What, I mean, in terms of what loss or what?
Yeah, absolutely. You've got to prove liability. You've got to prove loss. You've got to prove the breach. You've got to prove the loss. You've got to.
But if the company's shop sales have fallen, potentially the company is actually now in a better position because of having breached the object. And I'm just trying to think.
They may very well be. You're assuming that I had any kind of end goal in mind when I was writing this. Answers. Well, it'd be one of those where you just say, "Well, look, thanks, but it's your money." Just see how it goes, ride it out, see what happens. You're not in a brilliant position. The English courts wouldn't grant any kind of injunctive relief. As you said, there's not necessarily any loss. You just don't know. It's getting too far.
It's frustrating. The wrong has been done. And,
Yeah.
You want justice for your client? Not sorry, there is none.
Good. Well,
just find a director.
well, yeah, of course.
I mean, like I said, my point of going to that as a contrast to the first question is they're not all that in terms of the sheer volume of what you've got to work through, and in terms of identifying the issues, it can be a lot more straightforward. But that doesn't necessarily mean, again, that there's got to be a clear answer. In fact, for the reasons I explained this morning, I prefer to stay away from that, because if you've got two opposing arguments, then that is better, because it gives more scope for every student to do well, notwithstanding one may not choose a particular argument or may not even identify it. That's always the problem of having yes or no answers, is people get them wrong. We like to try and avoid that if we possibly can. The only other point then that I will make quickly is within that then 25 marks. I think Jasmine said from the outset, look, this is hard because how are you going to get 25 marks out of that? But again, remember what I've said, that 25 marks is encompassing both your demonstration of your knowledge and understanding of the law and the legal principles, plus then your application and your analysis and the advice that you give. So if you think you're working through a discussion of 114, you're working through a discussion of 115, you may be looking at, for example, that limited point on can she alter the articles or something like that. Chuck in a few marks for each of those, plus then...
We didn't know what I can do second.
Yeah.
I think once you look at the questions, I'm like, okay, I don't have to answer that one at all, and then it doesn't leave
Yeah.
a whole lot.
It doesn't leave. But then tracking in director's duties as well, you're only looking at one duty, but there's still a discussion there that's a good half page or so. And then you come through the advice. So maybe here, you know, it's going to be easier to get a decent mark, probably, out of that 25 than on question 1, perhaps. But that's the balance that I've got to try and find. Okay. All right, well, let's have our lunch briefly.